Donald Trump, through his presidential campaign for re-election, is suing the New York Times for defamation. I am predicting it now. This lawsuit is going to bring out one of the 101 do not do's in legal drafting. Viva Frei, Montreal litigator turned YouTuber, and it is yet another lawsuit in defamation. At this point in my YouTube career, if we can call it that, I have done a number of videos on defamation. We had a crash course in all things defamation with the Nicholas Sandmann series. I will link the Nicholas Sandmann vlog playlist right here if you have, 5 hours free time. Most recently, we broke down and analyzed Tulsi Gabbard's defamation lawsuit against Hillary Clinton. If you haven't watched that, I'm gonna link it right here. When the New York Times ran one of their multiple hit pieces on Brett Kavanaugh, I actually made a vlog pontificating as to whether or not Brett Kavanaugh could sue the New York Times for defamation. I will link that video right here, and I will link all of the reference videos in the pinned comment. And today on the legal menu, we have Donald J. Trump, through his presidential campaign, suing the New York Times for defamation for allegations they made in an article alleging that Donald J. Trump had an overarching deal with Vladimir Putin as relates to his re-election.
It never ends.
We are going to go through the complaint itself. It's not tremendously long, and we're going to go through the most important sections. And I'm thoroughly convinced that this particular legal situation is going to bring up one of the 101 do not do's in legal drafting, but we'll get to it at the end of this video. I am not going to go over all of the principles of defamation law. You can get those in any one of my previous vlogs on the subject. I'm just going to go over the essentials. Defamation takes on two forms, libel and slander. What's the difference? One is written, one is spoken. How do you know the difference? Through an alliteration that I've created: libel, literary, slander, spoken. It may vary by jurisdiction, but typically defamation requires the publication of a statement which is false, which causes damage to the person about whom the statement is made. The most notable exception to that jurisdictional rule coming from my home province of Quebec, where even the publication of a statement that is true can nonetheless qualify as defamation if the statement was published with the intent to harm. But at the very least in the United States, truth is the absolute defense to defamation. And to that end, at the very least in the United States, statements of opinion cannot be defamatory because they cannot be proven false insofar as they are statements of opinion and not statements of fact. With that said, let's jump right into the lawsuit.
I just sounded like Philip DeFranco.
Donald J. Trump for President, Inc., a Virginia corporation, plaintiff versus the New York Times Company doing business as the New York Times, a New York corporation, defendant. Jury trial demanded. Introduction and summary of case. 1. Defendant, the New York Times Company doing business as the New York Times, the Times, knowingly published false and defamatory statements of and concerning plaintiff Donald J. Trump for President, Inc., the campaign, claiming it had an, quote, overarching deal with, quote, Vladimir Putin's oligarchy to, quote, help in the campaign against Hillary Clinton, in exchange for a, quote, new pro-Russian foreign policy, starting with relief from the Obama administration's burdensome economic sanctions. And you know what? For fluidity going forward, I'm going to stop saying quote. I'm just going to hope you can deduce it from the tone of my voice and from the fact that the quote is in quotes in the document. The Times' own previous reporting had confirmed the falsity of these statements, but the Times published these statements anyway, knowing them to be false and knowing it would misinform and mislead its own readers because of the Times' extreme bias and animosity towards the campaign, and the Times' exuberance to improperly influence the presidential election in November 2020. The campaign therefore files this lawsuit to publicly establish the truth, properly inform the Times readers and the rest of the world of the true facts, and seek appropriate remedies for the harm caused by the Times' intentional false reporting. The first question here is who would be the party to have suffered the damages, assuming the defamation to be true? Reflexively, one would think that it has to be Donald Trump personally because the statements were made of and about Donald Trump. The same way as in the Tulsi Gabbard defamation lawsuit against Hillary Clinton, one could legitimately ask who suffered the damages, assuming the statements were defamatory. That said, in Tulsi Gabbard's lawsuit against Hillary Clinton, both Tulsi Gabbard's campaign and Tulsi Gabbard herself are plaintiffs. So already in that lawsuit, Tulsi Gabbard is sort of ahead of the curve to some extent, in that even if one were to argue that the campaign did not suffer any damages, assuming the statements were defamatory, Tulsi Gabbard herself is a personal plaintiff. If and when a motion to dismiss is presented, I am predicting that one of the bases of the motion to dismiss is going to be that the plaintiff lacks the legal standing to make the claim. Even assuming the statements are defamatory, they were made of and about Donald Trump and not of and about the campaign. And so to the extent that the campaign could not have been the entity to suffer the damages, even assuming the statements were defamatory, they lack the legal interest to be the sole plaintiff in this case. That said, that deficiency can probably be remedied as easily as adding Donald J. Trump as a personal plaintiff. But adding Trump as a personal plaintiff to the lawsuit would expose Trump to depositions in the context of that lawsuit. As it stands now, to the extent that it's only the campaign that is the plaintiff to the lawsuit, if the defendant insists on deposing someone, in theory the campaign can offer the most appropriate representative of the campaign for the purpose of deposition. And that need not necessarily be Donald J. Trump personally. I suspect that the Times would argue that the most appropriate and indeed only appropriate witness for the purpose of depositions would be Donald J. Trump himself, but that argument is there to be had. Whereas if Trump brings himself as a personal personal plaintiff to the lawsuit, I don't think he could refuse to submit to deposition. The second thing, the reason for which the plaintiff has filed this lawsuit. To publicly establish the truth and to properly inform the New York Times readers and the rest of the world. In theory, establishing the truth is pretty much the basis for any complaint. But I am not equally convinced that using court proceedings and the court resources to inform the New York Times reading is a legitimate use of court resources. If informing the New York Times readers was the sole purpose of this lawsuit, I could reasonably see a judge getting irked and saying there are better and more appropriate ways of doing that. And then we get into the parties. Plaintiff Donald J. Trump for President, Inc. is a Virginia corporation with its principal place of business in New York City, New York County, State of New York. On information and belief, defendant, the New York Times Company, doing business as the New York Times, is a New York corporation with its principal place of business in New York City, New York County, State of New York. Standard jurisdiction and venue clauses to establish the jurisdiction under the New York courts. And then we get into these statements of fact, which are not particularly complicated. In fact, there's nothing particularly complicated about this lawsuit. There is just one glaring omission and deficiency, which I'm going to get to. On or about March 27, 2019, the Times published an article by Max Frankel entitled "The Real Trump-Russia Quid Pro Quo," the defamatory article, which claims, among other things, that there was no need for detailed electoral collusion between the Trump campaign and Vladimir Putin's oligarchy because they had an overarching deal. The quid of help in the campaign against Hillary Clinton for the quo of a new pro-Russian foreign policy, starting with relief from the Obama administration's burdensome economic sanctions. The Trumpites knew about the quid and held out the prospect of the quo. And I think I just discovered a new word today. Trumpites? You know what? If the author of that article had the slightest bit of imagination, he would have called them trumpets. The defamatory article does not allege or refer to any proof of its claim of a quid pro quo or deal between the campaign and Russia. Rather, the defamatory article selectively refers to previously reported contacts between a Russian lawyer and persons connected with the campaign. The defamatory article, however, insinuates that these contacts must have resulted in a quid pro quo or a deal. And the defamatory article does not acknowledge that, in fact, there had been extensive reporting, including in the Times, that the meetings and the contacts that the defamatory article refers to did not result in any quid pro quo or deal between the campaign and Russia, or anyone connected with either of them. The story is false. The falsity of the story has been confirmed by Special Counsel Robert Mueller's report on the investigation into Russian interference in the 2016 presidential election, released on or about April 18, 2019. From a legal perspective, the timing of the publication of the allegedly defamatory article is going to be very relevant, and we're going to get into it. But before we do, it is not entirely surprising that the Times would publish such a blatant false attack against the campaign. There is extensive evidence that the Times is extremely biased against the campaign and against Republicans in general. This evidence includes, among other things, the fact that the Times has endorsed the Democrat in every United States presidential election of the past 60 years. Also, Max Frankel, the author of the defamatory article, described himself in an interview as a Democrat with a vengeance. The Times obviously had a malicious motive and also acted with reckless disregard for the truth. Extensive information, including stories in the Times published before the defamatory article, had put the Times and the world on notice that there was no conspiracy between the campaign and the Russian government, and there was no quid pro quo or deal between them. And then the complaint goes on to allege various statements and publications in the Times which allegedly contradicted any collusion or quid pro quo between the campaign and Russia. I'm not going to go through them, I'm just going to flash them with some soothing music and you can read them for yourself. The complaint alleges that the Times knew the information was false when they published it and refers to prior publications to evidence the fact that they apparently knew that there was no collusion between the Trump campaign and Russia. Why is the campaign doing this? Well, when it comes to defamation as relates to public figures, in order to succeed on the defamation claim, these statements need not only be false, but they need to have been made with actual malice. And this goes back to the landmark 1964 Supreme Court decision of New York Times versus Sullivan, which established the criteria that in order to succeed on a defamation claim against a public figure, the false statements have to have been made with actual malice. And to further the actual malice argument in this lawsuit, the plaintiff alleges that the timing of the publication of the allegedly defamatory article was in fact evidence of that actual malice, and here's why. On information and belief, the Times decided to publish the defamatory article when it did, in advance of the Mueller report, knowing that the Mueller report was likely to exonerate the campaign from allegations of collusion with Russia regarding the 2016 election. Once the Mueller report was released, the Times knew that any claim of conspiracy would not be credible. Thus, by publishing the defamatory article in March 2019, the Times sought to damage the campaign before the Mueller report would be released, debunking the conspiracy claims. The defamatory article defamed the campaign in its trade or profession because it falsely accuses the campaign of conducting an unethical and unpatriotic election campaign and colluding with a foreign adversary to improperly influence an election result. And then in paragraph 21, the complaint goes through all of the allegedly defamatory statements. The defamatory article contains false statements of fact, including the following. The real Trump-Russia quid pro quo. They had an overarching deal, the quid of help in the campaign against Hillary Clinton for the quo of a new pro-Russian foreign policy, starting with relief from the Obama administration's burdensome economic sanctions. The Trumpites knew about the quid and held out the prospect of the quo. Run down the known facts about the communications between Russia and the Trump campaign, and their deal reveals itself. But no such speculation is needed to perceive the obvious bargain reached during the campaign of 2016, and true to the campaign minuet, despite great resistance in Congress, President Trump has watered down the sanction and otherwise appeased Russian interests, even at the expense of America's allies. Call it the art of the deal. Paragraph 23, the campaign is conceitedly a public figure and the false statements were made with actual malice as alleged herein. And then we get to the relief sought, wherefore the campaign prays for relief as follows. Compensatory damages in the millions of damages according to proof, presumed damages according to proof, punitive damages according to proof, costs of suit, and such other and further relief as the court may deem proper. So those are the allegations, and they're pretty straightforward. The actual malice argument is predicated on the allegation that the Times allegedly knew that all of the statements they were making were false, but they made them nonetheless to damage the campaign. The timing of the publication of the allegedly defamatory article furthermore evidences the actual malice. That argument is to the effect that the New York Times knew with relative certainty that the Mueller report was not going to confirm any actual collusion between the Trump campaign and Russia. And so they deliberately published this allegedly defamatory article which confirmed collusion between the Trump campaign and Russia before the release of the Mueller report, which did not confirm any collusion between the Trump campaign and Russia. Think what you will of the argument, that is the argument. Now, in my very humble opinion, as drafted, this lawsuit is very weak. It's weak on the actual malice argument and it's weak on the defamation argument. But those are not the reasons for which it's going to fail. I think it's going to fail and fail fast for one very determinate reason, for something that was not said in these proceedings. For everything that was alleged in this complaint fails to mention the fact that the allegedly defamatory article was an opinion piece. And I think that the failure to mention that, let alone address it, is not going to be well received by a judge. It may be obvious because it says opinion above the article, but typically judges do not appreciate when a party omits legally material information from their allegations. And above and beyond the absolute defense of the truthfulness of the statement, one of the defenses is that these statements are matters of opinion and therefore not susceptible of being defamatory. All the campaign would have had to do is allege that sure, it says it's an opinion piece, but it is passed off as fact. I'm not convinced that argument would hold water at the end of the day, but at least you've raised it and addressed the issue. As it stands, a judge reading these proceedings might feel as though the plaintiff was trying to hide that fact from the court. Sure, the court would discover it, but it looks a lot better when the plaintiff discloses it willingly. So for that reason alone, I think this lawsuit is getting tossed sooner than later. That being said, I don't think this lawsuit was filed for the purposes of winning. I think it was filed for the purposes of publicity, and to the extent that multiple news outlets are covering it, mission accomplished. That, and I strongly suspect that this lawsuit was filed for the purposes of bringing back to the juridical fore the very issue that was resolved in New York Times versus Sullivan. I don't think it's coincidental that Clarence Thomas recently said that it might be time that the Supreme Court is called upon to revisit the principles set out in New York Times versus Sullivan. So Clarence Thomas has recently been questioning whether or not it is time for the Supreme Court to revisit that criteria, and I don't think it's a coincidence that the Trump campaign filed this lawsuit in that juridical context. Even if this particular lawsuit is, as we say in French, voué à l'échec, which means destined to fail, it might nonetheless spur that legal discussion. But this lawsuit as drafted is not only a losing lawsuit, it is a learning lawsuit in that it is illustrating the 101 of what not to do when drafting legal proceedings. Don't ignore unfavorable facts because they will invariably come to light and you don't want the court thinking you are trying to hide information from it. Don't ignore unfavorable facts so that you can address them before your adversary raises them. And that's all I have to say about that. If you like my content, if you like my videos, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below. If you want to support the channel, I've got a Subscribe Star account, a Patreon account. If you want to get some merch, all of the merch links are in the pinned comment below with a PayPal option for anybody who prefers that. And my podcast was just approved by iTunes, so when it's available, I'm going to send it around because I'm starting a podcast. It is called Viva Law Podcast. And now you know your vlog. Peace out. Booyah!